Okay, it's exactly 3 p.m. and we're ready to go. Good afternoon, distinguished colleagues. Good afternoon, panelists. Chinasa, good afternoon, Nta. Nice to have you all here. Today is day 2 of the intellectual property law series of the Practical Trading Academy. And it's my pleasure to welcome you here today on behalf of the TPTA. We're also happy to have the MBA ICLE who are monitoring here also today. Nta Ebiken Mbang will be moderating today's session, and our speaker is someone who needs very little introduction. Most of you will know Chinasa Wanna from other previous similar trainings, and she has a very rich career in intellectual property law that spans over a decade. And she worked for a long time with leading law firm Banwe and Igodalo, and now practices out of Canada. She's qualified to practice in both Nigeria and Canada. And you will find through this training that you wouldn't have many better people than Chinasa to talk about trademark law, branding conflicts, and reputation management. We're grateful to Nta and Chinasa who support the Practical Training Academy and are part of his IP faculty and indeed have coordinated these sessions for us. We continue to do what we do here. Our aim and focus is to do our best to make sure that Nigerian lawyers have the practical training required to do their daily work in line with international standards on continuing professional and career development. So without more, I'll invite Nta to do the formal introductions of the session, and then she will invite Chinasa, and then we'll take things from here. Thank you very much.
Good afternoon, everyone. For those of us who were here yesterday, it's the same format we're going to take for today. If you have questions, please put them in the Q&A section of the chat box of the webinar. And Chinasa is going to take us through the training for about 1 hour 30 minutes, or maybe. And then after that, we're going to take questions. I will come back to moderate the questions. Please if you can keep your questions short and practical, and then we will see how it goes with the question session. So Chinasa, are you ready? So we can start.
Thank you very much, Nta. Thank you, Tobina, for that brief introduction. Good day, everyone. It's my privilege to be a part of this series and to present to my fellow lawyers. I know it's always a difficulty for lawyers to speak to lawyers because the assumption is that they're already a bit knowledgeable about what you want to say. But it's a privilege for me to talk about intellectual property, something I'm very, very passionate about. And on the topic, trademark law, branding conflicts, and reputation management. Yesterday, my colleagues, Mr. Christian Anuku and Ms. Tsai Keng Wang, discussed foundations and legal framework of intellectual property in Nigeria. And I believe that tomorrow, Ms. Obafemi Agaba will speak to enforcement and emerging issues, as well as opportunities in IP law. So I'm not going to dwell so much on those issues today. However, I'll be highlighting a few issues in trademark law and discussing branding conflicts and reputation management. My presentation will touch on the meaning of trademarks and brands, examine the complexities of brand conflicts, and the critical role that lawyers play in safeguarding their clients' trademarks and brand reputation. So the objective is really to strengthen our understanding of trademarks used in business and equip ourselves better to advise clients in a manner that protects and enhances their brand and reputation. Regrettably, we have only 2 hours, which is not enough to just hold, please, to dissect all the issues, but I will endeavor to provide an overview which should serve as a foundation for further consideration and research. So I'll start by saying that some recent decisions of the courts, this is my introduction, also indicates that the courts consider brand protection of high importance. For instance, in March of this year, that should be this year, 2025, the Federal High Court awarded damages in the sum of 840 million naira against MTN. In the case of CityLink Access Core Limited versus MTN Nigeria Communications and the Register of Trademarks and Patents and Designs. In relation to, and I'm going to make some of these cases available at the end of my, because we'll talk about a lot of cases at the end of my presentation. In relation to the infringements of City's Web Plus trademark, which it had registered since 2021. Some other recent and interesting decisions of the Federal High Court, which is the court of jurisdiction over IP matters, include the Sanofi and Sanofi Integrated Services Limited, Sanofi Nigeria Enterprises Limited case, which over a dispute over the name Sanofi. You know that Sanofi is a French healthcare company, Sanofi SA. It sued various Nigerian companies that was using its trademark Sanofi, which it had registered since 1987 in their corporate and or trading name. So examples of those companies included Sanofi Integrated Services, Sanofi Nigeria Enterprises, Sanofi Nigeria Enterprise, and so on and so forth. In the cases I mentioned now, this MTN case and the Sanofi case, the Federal High Court ruled in favor of the claimants and ordered the removal of the infringing names from the register of companies. So there are so many other cases, and I trust that Mr. Gaba will touch on those cases tomorrow. But just let's first of all have an understanding of what trademarks are. What are trademarks? So what is a trademark? What is a brand? They are often used interchangeably, and we will not enter into I'm not going to enter into a detailed, investigation, aimed at distinguishing them. For our purposes, suffice it to state that the term trademark is often used in the legal context. So when you're talking about the legal context, or it's a legal concept, so to speak, whereas the term brand is typically used more in marketing or in the commercial, context. According to the World Intellectual Property Organization, a trademark is a sign capable of distinguishing the goods and services of one enterprise from those of another. And according to I'm just using some quotes from bodies that are well known in these areas of the American Marketing Association, a brand is regarded as a distinctive feature, like a name, term, design, a symbol that identifies goods or services. So essentially, a brand is a totality of a business's public image, the reputation, the identity, typically associated with the trademark, or usually identified as a trademark. Under Nigerian law, interhold please. Under Nigerian law, trademarks are governed by the Trademarks Act, Cap T 13, Laws of Federation of Nigeria 2004, and administered through the Trademarks, Patents and Designs Registry. Section 67 of the Trademarks Act, that's the interpretation section, defines a mark to include a device, a brand, note that word, heading, label, ticket name, signature, letter, word, numeral, or a combination of that. So trademark is therefore basically a mark used in commerce, and depending on how you look at it, it could include or form a part of a brand. And I'm going to just quickly touch on a case. So hold on. Which I believe really buttresses this point about trademark versus brand and all that. And that's the case of the International Tobacco Nigeria Limited and 3 others versus the British American Tobacco Company. In that case, the gold label of this is Benson and Hedges, as most of us know, was an issue, right? The British American Tobacco and Benson and Hedges, they are the respondents at the Federal High Court, and they had registered their trademark Benson and Hedges with the gold color label. It's a gold color label mark and all that, you know, ever since. And it was clearly registered with relation to the color gold as part of the component of the trademarks, to which the respondent as proprietors, you know, had a right. However, uh, the other guys had gone ahead to register a trademark they called tradition, and that trademark, you know, had the gold color. Although they didn't call theirs Benson and Hedges, they called it tradition, but it still had that, you know, golden color or device that they used to package it, you know. And so, of course, BAT sued them, British American Tobacco sued them, and they were successful at the trial court, at the Federal High Court. But they are aggrieved by the decision of the court, the appellants, that is the respondent, International Tobacco Nigeria Limited, aggrieved by that decision. They appealed to the Court of Appeal. The Court of Appeal also, you know, went ahead and affirmed the decision. They were further dissatisfied with the Court of Appeal's decision, and then they appealed to the Supreme Court and raised an issue for determination, that is, whether the sale by the appellants of the cigarette brand as tradition, packaged in a gold colored, get up or whatever, was infringing to the respondent's registered trademark. In resolving the issue, the Supreme Court held that an essential element of a device claimed to be a trademark is that it identifies, you know, the goods of a particular merchant and distinguishes them from the goods of others. So whether it's a word, a symbol, a color, a shape, whatever it is, you know, it is part of what gives a business its identity, you know. And so in determining whether there has been an infringement, the focus lies on the offending mark. If the person encountering the offending trademark in the absence of the genuine one would think that, oh, or be deceived or mistake it for the other one, you know, mistake it for the authentic registration, authentic trademark based on their general recollection, then the infringement may be established. So in the present case, the Supreme Court held that the tradition cigarette with a gold-colored pack infringed on key features because it closely resembled and, you know, appeared identical to the the popular Benson and Hedges trademark. Again, it's important to note that Section 68 to 69 of the Business Facilitation, you know, Miscellaneous Provisions Act 2023 amended Section 67 of our Trademarks Act, you know, and then by so doing, it expanded the definition of goods to include services, and so it reflects a broader recognition of trademark protection in the digital age, because it now includes things like non-traditional trademarks, like the shape of goods, their packaging, combination of colors, and so on and so forth. So what am I saying in essence? A trademark could be a totality of everything. I mean, a brand rather could be a totality of everything, right? The words you use, the logos you use, the device you use, the combination of everything, the colors, the scent, three-dimensional shapes, everything that gives you your brand identity. It could even be like what, you know, the kind of thing that makes you appreciate, or your perception of a business. Everything that would cause you to think about a business or identify it is your trademark and it's your brand, right? From a legal point of view, a legal standpoint, a trademark grants the owner exclusive rights to use or authorize its use. Thus, it holds a lot of commercial benefit. I remember when we started, we said that trademarks are usually typically used from the legal sense, whereas you talk about brand when you're talking about commercial sense, marketing, and all of that. But they are so intertwined, is my point. And they could, I mean, even in our definition of mark, we see that the law Trademark Act actually mentions brand as part of the definition of a mark, and so on and so forth. And also in the definitions we gave from WIPO and from the American Marketing Association. Next slide, please. So I'm just quickly going to highlight the registration process. Like I had hinted earlier, I'm not going to spend so much time discussing trademark because this has already been dealt with in the previous discussion yesterday. However, it's very, very critical that I reiterate the key steps in trademark registration process in Nigeria. because this is crucial in discussing, branding conflicts and steps that lawyers can take to assist their clients in protecting their brands and managing their brands. So the first thing I'm going to talk about is conducting a search at the trademarks registry. This search is optional, but it is recommended, and most people say, oh, must I conduct a search for my trademark before I register it and everything? What's the essence? Because it's going to cost extra money. Why don't I just go and file my trademark? And after all, it's going to be examined at some point and all that. But the point is, it is really, really recommended, and we'll see that from some of the cases soon. So let me just quickly warn you that we're going to be looking at a couple of cases as we go about, because we're talking about branding conflicts anyway. We will see that it is very, very important that you clear your search. Make sure that you have, established that there is no conflict, or at least as far as as far as the records show, that there's no conflict, or there's no issue, or there's no prior trademark or something like that. It's not already in existence. Nobody is using that brand before you go and expend so much money, on it. So as a lawyers, it's our responsibility to advise our clients before they go and start, having very big launches, spending money, branding and all of that. Let them know whether this trademark that they want to use is actually available. So I would say it's optional, but it's strongly recommended. The next step is filing an application under the appropriate classification. So again, in Nigeria, we use what we call the NIST classification of goods and services, which basically lists every good or service on earth into about 45 classes, depending on what. And it is important that you file your client's trademark in the right class. Because if you use so for instance, class 5 deals with pharmaceuticals. If you go and file, and then class 3 deals with cosmetics. If you go and file your client's cosmetic product under class 5, it may not give your client the protection that your client requires. So it's important that you file your trademark in the correct class. Then there's administrative examination of the application, which is kind of like official checks to see if there's any prior mark that is on the register of trademarks. If the mark is disallowed for any reason, for instance, if it's against the law, if it's scandalous, and things like that. Where the trademark passes that stage, it goes on to the publication stage in the trademarks journal. That is now opportunity for any third party or anybody at all. Our law says the language of the Trademarks Act is anyone who who feels that, and then it goes on and on. If there's any reason for you to oppose the trademark, you can. So, for instance, if there's an existing trademark that somehow was missed during the official examination, or if there's a distributor that is being mischievous and trying to file its the licensor's trademark prior to the licensor coming to file it in Nigeria and things like that, right? Or if there's any bad faith and so on. Where the mark goes through there's a 2-month period for anyone to oppose any registration, any application that's advertised in the Trademarks Journal. Where the mark successfully passes that 2-month opposition period, or yes, there's an opposition and it successfully overcomes the opposition, the next stage will be to go to pay the sealing fees, issue the certificate of registration by the registrar, and then afterwards you have to maintain your trademark. Now, why is this important? Practitioners must ensure that clients register their trademarks in all relevant classes, consider renewal obligations it's not every 7 years. First, the trademark is renewable for the first at the first instance 7 years after registration, and then every 14 years subsequently. So it's important that you as a lawyer, you keep your vigilance and you ensure that your client's trademark registration is renewed as at when due. And then we should also exercise caution in issuing cease and desist letters when it comes to trademarks. Verify whether there's already a valid registration in existence, whether the mark qualifies as a well-known trademark, and so on and so forth. So it's very, very important to understand the procedure for trademark registration, because to mitigate conflicts in future, you need to know if there are prior marks that have, or their prior rights to the trademark or the brand that your client is using or wants to use. You need to be sure that even as far as corporate names, and we'll talk about that very quickly. Make sure that before your client goes into enters the market or expands his business or whatever, that it's not going to be infringing on any existing trademark. We have legal provisions in that regard, and so you can minimize conflicts. Rights of a legal rights of a trademark owner. I'm not going to dwell on it. Rights to to use the mark, to exclude others from any unauthorized use, to sue for infringement, to license or assign the trademark, that's to commercialize your trademark or your brand, to oppose any conflicting interests, and so on and so forth. These rights enable, the legal practitioners to help their clients in negotiating complex commercial agreements, such as licensing, franchising, co-branding, and so on. They also form the basis of enforcement before the Federal High Court, underscoring how important, both trademarks are as both legal and commercial assets. However, I must, note a note of caution here. It's important to know that although registration already, strengthens a trademark owner's legal position by establishing a presumption of ownership and enforceability, what that simply means is that if I bring my trademarks certificate of registration, it is proof that it's prima facie proof that I own the trademark, subject to whatever would cancellation or invalidation proceeding that might follow. So it's not that it's that once you have the trademark certificate, that's all. And this decision, this position was actually highlighted in a very recent Supreme Court decision, a 2024 Supreme Court decision, Deck, Joe Motors, and another versus Allied Signal, INC and another. In that case, the first respondent, an American company, the producer of brake and clutch fluids, and the owner of various trademarks, registered under various classes. It had trademarks like Allied and Device, Bendix and Device, DBA and Parallel Lines Device, ER, and so on. And it would use it to manufacture and sell its goods for motor vehicles. The second respondent was a subsidiary of the first respondent and equally is into the business of manufacturing and sale of brake and clutch fluids in Nigeria, using the first respondent's trademarks, Bendix and Device. The second respondent had continuously marketed it, in Nigeria and was relatively well known in the industry and all that. When in 1992, the appellant commenced marketing of a brake and clutch fluid known as Allied, with similar design, similar trademark, and very, very, imitative of that of the respondents' Bendix and Device trademark and all. So the respondents were the plaintiffs at the trial high court commenced the action at the Federal High Court in Lagos and claimed that their registered trademarks, were being infringed by the appellant. The respondents also claimed passing off because of the design that was used by the appellant in their brake and clutch fluid cans. They were very, very similar. The get up and all of that looks like theirs. Just a second, please. Okay. Sorry about that. So the appellant in defense stated that there was no form of infringement. They claimed that, they don't manufacture, or rather they actually purchase and sell brakes and clutch fluids using the trademark and all of that from a third party. They'll say they used to buy it from another party, a third party called Frank Nigeria Limited and all that, and after the trial even commenced, they filed an application asking the court to strike out the suit for being frivolous, vexatious, abuse of court process, and so on and so forth. At the trial court, the application was dismissed, right? And then it culminated in an interlocutory appeal before the Court of Appeal, which was also dismissed. And then the matter went on appeal to the Supreme Court. The issue before the Supreme Court was whether by reason of the events following the institution of the action, the continued prosecution of the claim of the plaintiff was an abuse of the court process. And this was the decision of the court. Well, before then, the appellant argued that the infringement action commented by the respondent at the trial court was vexatious and all of that, that they had registered the trademark at the trademarks registry. They even had a trademark registration certificate that with them, which amounted to a valid and complete defense to the infringement. I remember we had said that once you produce a trademark certificate under our law, it's prima facie, proof of ownership, and then you have to now, the onus of proof now shifts to the other party to show that, that registration is not valid and all of that. And so the argument, the applicant's argument was, look, we even have a certificate of registration to show that this mark has been registered and all of that. The Supreme Court dismissed the appeal. It held that first of all, it held that the suit was not an abuse of court process, because it defined an abuse of court process to mean proceedings that commence with an element of malice, deliberateness, desire to annoy the opponent, and so on and so forth. However, in talking about whether the presentation of a trademark certificate is a complete defense to an infringement action, the court held that Section 13 of the Trademarks Act, which provides for the independent use of identical trademarks and allows for bona fide claim to the marks by each party, does not support the appellant's claim because because they claimed honest concurrent use. Honest concurrent use is a situation where, oh, you have this trademark and I also have it, but we came up with it independent of each other and we've been using it, and therefore we have, we can use, the court should declare that we use it honestly, concurrently, and all of that. So maybe, oh, I inherited a trademark from my mother. She used to use it 20 years ago. This one says, no, but I developed it. I was discussing with my daughter and the word just came out of her mouth. I tried to use it as a trademark. And then we've been using it for so and so years and nobody said anything. So let us exist concurrently. That was their argument. That was one of the arguments that the appellants had put forward. But the court rejected it. It said, look, relying on honest concurrent use was misconceived and premature. It cannot be established on the basis of an objection taken in based on the fact that there was already an existing trademark and an existing trademark on the register. These people were already using it. You can't wake up one day and say, oh, but I have a certificate of registration. Therefore, because of that, it's honest concurrent use. Let me use it. Let me continue to use. And you're copying exactly what they use. You're using their name, using their get-up, you're using their whole brand and all of that. Anyway, the point I was just trying to make in all of this is that whilst the production of a certificate of registration, trademark registration, shows that you are the owner, is a valid proof of ownership of a trademark, let's not just rely on that and assume that, that in all cases it's not rebuttable or that it cannot be invalidated and all of that. In this case, where, for instance, bad faith and infringement had been, was proven, the Supreme Court held otherwise. And so now diving into the meat of our conversation this afternoon, I want to talk about common branding conflicts. These are conflicts that exist when two or more entities use identical or confusingly similar, matters. One of the easiest one is using the similar mark on similar goods or services. So is my trademark, like the case of the Sanofi, I gave the example, Sanofi, and another person uses Sanofi on their trademarks, maybe on their goods or on their pharmaceutical products. In the case of the MTN, the MTN case I mentioned earlier, CityLink Access Call Limited versus MTN, where the marking issue was WebLink, and MTN was using WebLink. I don't know, many of you must have seen it, Web Plus, WebLink Plus, and all of that. And Cityco had already had a registered trademark. That one is very, very clear. It's straightforward and all that. That's one branding conflict that typically arises, and typically people go, to court or go to dispute resolution to sort it out. Another type of conflict is where the corporate name conflicts, the corporate name, the name registered at the CAC, Corporate Affairs Commission, conflicts with an existing trademark, a trademark that is already on the trademark register. So we touched on this briefly when we talked about the Sanofi case above and Citigroup and all that. Section 31D of the Companies and Allied Matters Act, Cap 20, Laws of Nigeria, talks about prohibited and restricted names, and it says that no company shall be registered under the Act by a name which, in the opinion of the Commission, would violate any existing trademark or business name registered in Nigeria, unless the consent, obviously, of the owner has been obtained prior. So that section is very important because it says any existing trademark. So if there is a trademark that has been registered, it's in the register of trademark. You are prohibited from going to register your business name or your company name under that name of the trademark. Section 8521D of the Companies and Allied Matters Act as well talks about, it says no company, limited liability partnership, business business name, incorporated trustee shall be registered under the Act by a name or trademark which, in the opinion of the Commission, would violate or conflict with any existing trademark or business name registered in Nigeria or body corporate formed under the Act, unless the consent of the owner of the trademark, business name, body corporate, and so on has first been obtained. That really should be read together with the preceding section 31D that I had mentioned. So basically, what this means is that sometimes, because we have two different registries in countries like Ghana, for instance, there is one corporate registry and a couple of other countries as well. So as you're conducting a name search, it checks the databases basis for trademark, check the databases for trademarks, for companies, business names, everything at once, even for domain names and all that. However, we have separate regulators for these in Nigeria. So we have the Corporate Affairs Commission dealing with company registration and things like that. We have the Trademark Registry dealing with trademark. So if you conduct a search at the Trademarks Registry for a name, it doesn't automatically translate to a search at the CAC and vice versa. However, upon what the law says, when you're going to go and register, if there's already an existing trademark, you cannot go and register your company name. So let's say there's a trademark Chinasa, right? Then you now say, oh, the trademark Chinasa that is on the register. You say, oh, you want to make your company Chinasa Nigeria Limited, right? You're precluded from doing that. That's what this basically says. And so what this also now tells us as lawyers is that we have to be a bit more vigilant. It's not enough to just say, oh, I conducted a search at the CAC, or the name was available. Okay, you can go ahead and register. And then you now register a company name that now infringes on a trademark that is being used in commerce. That's what this is about, right? And these are some of the conflicts that come up. I've talked about the Sanofi one, where there was Sanofi Enterprise Limited, Sanofi Nigeria Enterprise Limited, Sanofi this, Sanofi that. Meanwhile, everybody knows the very big, or most of us know the very big French conglomerate, French pharmaceutical company, Sanofi SA. And so that was a problem, and they went to court and were successful in that court. Again, in the very high court case of Havells India Limited, which is another recent case, 2023 case where the Corporate Affairs Commission and Havells Product Limited. The court ordered the registration of the company MDC Havells Product Limited for trademark infringement of the registered trademark Havells, which was owned by Havells India Limited. So in summary, the Federal High Court just ordered the Corporate Affairs Commission to delete and strike out the name MDC Havells Product Limited from the register of companies, further issued a perpetual injunction preventing the company from further infringing on the Havells trademark, and ordered that the infringing materials with the Havells trademark be delivered for destruction. Another very common branding conflict is online conflicts, right? We have digital markets have increased in recent times. The incidents of brand misuse online, there's common challenges, include cyber squatting, the rise in this age of social media. You have all sorts of unauthorized brand use on social media. There's keyword advertising, using computer trademarks, and so on and so forth. So to check this, or to control this, legal practitioners have to guide their clients through defensive and offensive strategies. We have to come up with all sorts of ingenious ways to protect their digital brand presence. One of the commonest one is this trademark spotting by distributors. Sometimes it's your distributors, sometimes it's your business partners, sometimes it's even with competitors. It does basically involves bad faith acquisition of domain names. You know that the domain name is not your own, or for whatever reason you want to go and obtain it and use identical or confusingly similar and prior existing trademarks in your domain name. And under the Nigerian Cyber Crimes Act, it's a criminal offense, actually. But it's unfortunate that it's still a very, very common thing, and a lot of people seem to get away with it. And that again is why lawyers have to be very, 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 very diligent in looking out for their clients' matters. One interesting case in this regard is the Konga Online Shopping Limited versus Rocket Internet GmbH and its subsidiary Jumia. And I'm sure you're familiar, you know that Konga and Jumia are in the same business and all that. So imagine that Rocket Internet GmbH, went ahead to go and register some domain names using the Konga name. This case didn't go to court. It went to the WIPO, that's the World Intellectual Property Organization, UDPR resolution process. UDPR is the Uniform Domain Name Dispute Resolution process. It's what that was established by the World Intellectual Property Organization for domain name disputes. So it involved the alleged cyber squatting of various domain names by Rocket Internet, including conga.sc, which they claimed was conga. That it was for Seychelles, and it was not in Nigeria, it had nothing to do with Nigeria, they were not affecting Conga's business in Nigeria, and so on and so forth. Although the complaint was eventually dismissed, it was because Conga did not put forward sufficient evidence to prove its case. So what it talked about was, it produced or provided Wikipedia write-ups on Conga, talking about the company, the business, the staff, the employment, their reach, the advertisements, and things like that. But they didn't bring any, substantial evidence to buttress that fact. And the court and WIPO said, you know what? Wikipedia is not a reliable source of evidence. Like, anybody can go and write anything they like on Wikipedia, and write it to their favor. So that wasn't countenanced by the administrative tribunal. And then and also they were supposed to prove certain things. For you to succeed in a WIPO dispute resolution process, you're supposed to show that the domain name is actually identical or confusingly similar to your trademark. The trademark has to be registered. Conga didn't provide proof of any registered trademark at the time. What they had were pending trademarks, like trademarks that they had filed and hadn't gotten the certificate of registration at the time. And so, and you have to also show that you have legitimate rights to the domain name and that the domain name was registered and used in bad faith. But you have to show all 3 points to be able to succeed in a UDPR process. And unfortunately, Conga wasn't able to do so. And so they lost that case. Another one is parallel. Well, I want to just quickly note that Nigeria has a similar dispute resolution process for domain name issues or online disputes. That one is administered by the NIRA, the Nigeria Internet Registration Authority. And again, there are other forms of conflict, including parallel importation, where someone is importing products, bearing the same name and all of that, not necessarily claiming that it belongs to them, but then they're selling off the product, they're selling, them in the marketplace. Then there are licensing risks as well associated with this. This is where you have your distributors, franchisees, licensees, and all of that based on your commercialization of your products and all of that. And then you're trying to expand, through your licenses and franchising and all. But then there are so many risks associated. There's dilution of your product, dilution of your mark or your brand. In the case where there's so many people using it at the same time and all that, maybe you have quality control issues that, and your quality control is inadequate. There are breaches of licensing obligations, there are cross-border enforcement challenges, and so on. So what am I saying? Lawyers need to ensure that there are strong contractual safeguards and terms which can protect your client's brand, at all time. There are legal remedies for infringement. And I'm just trying to rush over this. Like I said in the beginning, that 2 hours is not really sufficient to go through all of these. Some legal remedies for infringement include injunctions to restrain further infringement, damages, or an account for profits, delivery up, or description of infringing products, and some pillar orders, and so on and so forth. However, what's the point to note is that courts require credible evidence demonstrating a likelihood of confusion. As such, consumer surveys, marketing materials, sales records are often instrumental in substantiating infringement claims. This is why, like in the Conga case that we mentioned, Conga, in my view, and this is my personal view, had a very good case. They have a thriving business in Nigeria. I know it's very popular at least in Nigeria and all of that, just like Jumia, I know. But then when they went for this dispute resolution process, they were not able to provide credible evidence. They just said, oh, printed out something from Wikipedia and went with that, and they said, no, you have to show your sales records. We need to see more tangible details and things to show that you are actually the owner of this trademark. You have to see your trademark registration certificate. They couldn't provide any trademark registration certificate. We need to see your consumer surveys and things like that, your sales records, stuff like that, and they were not able to provide it. So in talking about, oh, I want to protect my client's brand, oh, there's a conflict, we want to ensure that everything is okay. You have to be sure that you have the credible evidence, to show and to provide to them. And then I'll quickly touch on passing off. And this is because I know the question would be, okay, so if I don't have my certificate of registration, if I haven't registered my trademark, does it mean I don't have any recourse to law? There's nothing I can do. If I have a conflict, if someone is, using my product, my brand, is there nothing I can do? So I'm just going to say that even though trademark registration protects legal rights, that is, you've registered your trademark and all that, you have clear legal rights, even without registration, common law protection may be available, through the thought of passing off. In this case, you have to, prove the elements of, a passing off case. You have to prove that there's existence of goodwill in your brand. You have to show that there's a misrepresentation, or there's likely to be a misrepresentation that would lead the public to believe that the goods or services emanate from the claimant or the plaintiff. You have to show actual or potential damages to your goodwill, and so on and so forth. The notable authority in this case is Niger Chemists versus Nigeria Chemists Limited, which is a 1961 case. I'm not going to go into the details of that case. So although passing off offers some level of relief, let us all clearly let our clients know that registration remains the best protection and should be pursued promptly. Quickly, to go to conflict avoidance strategies, because it's one thing to now go to try to resolve conflicts when they arise. The best thing is to avoid it in the first place, in my opinion. So to prevent or reduce disputes, lawyers need to learn how to implement proactive measures. I recommend that we implement proactive measures. This would include, like what we talked about, clearance searches prior to adoption of a trademark. Before your client starts using I can't overemphasize, before your client starts using a trademark or a mark or whatever, let clearance searches be done. Parties should also learn to negotiate coexistence agreements where necessary. Sometimes it's not so much about being right. There are things that I talked about honest concurrent use earlier. It's possible to exist, concurrently. If your business is not necessarily, if your target group or your target audience or whatever, it's not the same as mine, we can actually exist even though we're using similar or even identical marks, as the case may be, right? We could even leverage on each other, as the case may be. There have to be comprehensive IP related provisions in commercial contracts. In this day and age, it's very, very laughable for any serious minded commercial agreement not to have tight IP provisions that protect the brand. Particularly if you're going to be going to a joint venture, or you're going to be, doing a business that would involve more than one company or entity and all of that, you want to be sure that you've protected the IP. And the IP provisions are different. Protecting yourself internally in case you have staff that are either creating stuff or coming up with IP ideas, and if you want to be sure that you own the IP asset. When you're dealing with third parties as well, you want to be sure that your IP assets are clearly stated, who owns what. If you're going to be co-creating IP, it has to be very clearly stated. Would there be joint ownership of the IP that is created, and so on and so forth, right? And then there should also be internal training on IP for every organization, and even for lawyers as well. Like, you need to understand what intellectual property is. I guess that's why we're having what we're having right now, this series on IP, And then not just that, but also for the client, you need to explain to them that they have to understand training with their marketing team, their commercial teams on the appropriate use of IP, because they could also by themselves dilute their IP, or even make it susceptible to infringement if they don't know how to manage it. Every client should be able to appreciate what's my brand, what's my brand identity, what am I trying to do here, how do I protect my identity, and all of that. That would help you to first of all identify internally as a company, this is what my IP is. Then you think about strategies to protect. Be sure that you own the IP that you think you own. Again, so that you don't go and use another party's IP and then get into trouble. There have been cases where, and it's typically, in my experience anyway, it typically comes up with distributors, licensees, and the rest of them, where they don't know the extent of their rights, even though they should because they have the licensing agreement. But a lot of times, some of them go overboard and use the IP belonging to the licensor in a way that is not, in tandem with what the rights that they have been granted. You know, and I mean, all of these measures would help to protect your brand value, reduce litigation, that's the company's brand value, reduce litigation, and enhance business, outcome. Quickly, I'm going to just talk on reputation management. Nta, I don't know if I still have time.
Yes, Chinasa, you do have time, at least another 45 minutes.
Okay, so I will just quickly touch on reputation management. You know, I mean, from the foregoing discussions, it's very clear that a trademark is intimately connected to the company's reputation and brand and can have a significant, impact on its commercial value. Some of the tools for managing reputation include, defamation proceedings, addressing false claims, enforcement actions against counterfeiting or misleading use of trademarks, consumer protection measures under the FCCPC Act, coordinated app. I mean, you need a coordinated approach, that integrates IP, defamation actions, consumer protection, and all of that to safeguard your client's reputation and safeguard and manage your client's reputation. However, of more importance to me is to discuss the role of lawyers in this, right? Like, how would lawyers help the clients to ensure that this is done? The first thing I'm going to, shout and shout and shout is due diligence. Lawyers need to be very, very, very vigilant from the get-go, and encourage their clients to conduct expedited risk analysis assessments periodically. What does this mean? Like, you should encourage your clients to register their trademarks early in time. I mean, register your trademarks on time in all the relevant classes. So not that you just register your trademark, but make sure you register your trademark in all the relevant classes. And I would give an example. So I talked about class 3 of the NIST classification covering cosmetics, and class 5 covering pharmaceuticals, and maybe class 10 would cover something like medical devices and all of that. And these are classes that are distinct but are somehow related. So in the fact that so if you have like a soap, a tablet of soap, right? A tablet of soap would fall ordinarily under class 3, which is for cosmetics. However, if it has antiseptic qualities and all of that, it may also fall under, class 5, which is for pharmaceuticals, because you could use it for, maybe if you have, I don't know, skin disease or something like that to wash. Again, there could be a way that maybe there's some instrument or so that you use for the soap or to get it out and all of that, that would fall under medical device, which is class 10. Going to go and register your product in class 3 alone may not, it will protect you, but it may not necessarily give you as wide a protection as if you registered in the other 2 classes I had mentioned. So that's what I mean by in all the relevant classes. Again, your domain names, secure your domain names, and don't wait until there's a problem. Like, let us not be reactionary. Wait until there's a problem, and we say, okay, let's go and register our domain name, or let's go and let's run to NIRA or run to WIPO and see how they can help us. There should be clearance searches, a comprehensive clearance searches, both at the trademarks registry, at the CAC, and all that. This is also, I mean, on the side, this is also a source of income for lawyers. Lawyers should also ensure that their commercial agreements contain robust IP provisions to protect the client. We talked about that. Clients and lawyers should also maintain active brand monitoring, what we call watch service, right? The fact that I've registered a trademark or registered a company name doesn't mean I should go to sleep. I should also be looking out for my client. Like, is there anyone that is infringing? I talked about the trademarks journal that is published periodically. When the journal is published, it's the work of or the duty of the lawyer to go and check the journal to be sure that, okay, nobody has come to my register, apply to register something that is similar, confusingly similar, or identical to my client's product. And I mean, we've done in my history, in my years of experience and doing watch service for clients, we've come upon loads and loads. You'll be shocked at the number of infringing applications you will find. Some of them inadvertent, but most of them deliberate. You'll find that, oh, the person that is trying to register is a former licensee or is a licensee or is a company you've done business with or a competitor. Or so it's very, very critical that lawyers pay attention to this. And then there should also be a strategy for cross-border filing and enforcement framework. So if you know that your client has businesses in other jurisdictions, it's a good idea to advise them to look into filing registrations there if they have business concerns there. Let it not just be, oh, in Nigeria and you go to sleep, you know. Seek injunctions to halt dissemination of misleading information. Lawyers should have good relationships with regulators like the Trademark Registry, NCC, FCCCP, NAFDAC, SON, and so on, where relevant. You know, review contractual relationships and licenses for vulnerabilities. When your client comes up with agreement that they want to sign and all that, we should be very, very careful. It's a coordinated approach. And what I'm just trying to say in essence is that let it not just be about us reacting to what has already been done. You know, in protecting our clients' reputation, we also want to be proactive. We also want to help them from the beginning, not that. And I say this, with all sorts of responsibility, because in my years of experience, that you'll be shocked at some of the very, very big names in the country that don't have an IP strategy. They don't have an IP strategy for their brands. And then you find out that they are just leaving money. Either on the one hand, they're leaving money on the table. Sometimes their staff are even walking away or walking out the door with their IP and going elsewhere and using it and profiting from it. Sometimes that they're not even profiting from things that they could profit from, and it's just there looking, staring them in the face. Other times is that they are just rushing running straight into conflicts, like staring them in the face, and they're going in there because they don't understand these issues of branding, brand protection, their reputation, being proactive and taking steps, and all of that. I'm going to stop here. Like I said, it's a coordinated approach. Effective trademark management is both legal and strategic business function. And lawyers who appreciate this dual function, this dual significance, actually deliver exceptional value, and that they're the ones that make a difference, in the legal space, guarding brand equity and facilitating commercial expansion. And you find that you become, your clients wouldn't want to take any step without you because they rely so heavily on the value that you're bringing to the table. Unfortunately, my slides don't have all of the cases I've mentioned, and I'm going to ensure that they are shared or circulated subsequently. But then I'm just going to mention a few of the cases again, just for anyone who is interested in following up or doing some further study. There's Ferredo Limited versus Ibeto Industries Limited, 2004, 5 NWLR, part 866317. Nigeria Chemists versus Nigeria Chemists and others, the 1961 case. Virgin Enterprises Limited versus Rich Day Beverages Nigeria Limited, 2009, LPELR 8187CA. Alliance International Limited versus Samcolo International Enterprises Limited, 2022, LPELR 57984SC. Morrison Industries PLC versus CPL Industries Limited, 2021, LPELR 52981CA. And like I said, we'll share some of the other cases I had mentioned, the Sanofi, the MTN, Citigroup, and so on and so forth subsequently. Thank you very much.
Okay, so thank you, Chinasa. So what I'm going to do now is, I hope we can all hear me. So we're going to take, so thankfully, because we have at least an hour, So we're going to take all of, as many questions as we can. But like I said yesterday, I don't know if I said it yesterday, for those of us that are in this session, who are interested in intellectual property law, like all things, it's in the doing that you get to know more. Just acquiring the knowledge is one thing. But Chinasa started her practice in Jackson Etienne Edu, and Jackson Etienne Edu is a known IP law firm. Before moving to Alukwano Yebode, she was in the IP department before moving to Banwa Nikudalo. And now she's, practicing in Canada. Chinasa does just IP, right? The business, the practical part of it. So she's able to see these issues, understand these issues. Same thing, for myself, which is the point that I need to stress that you will get to understand IP more, in the doing. You have to do it. It has to be something that you do every day. You can't just, have the knowledge of it and, go away till another training. It is in the doing, in the everyday doing, that you would get to understand how IP works, the practical part of it, how it works. Okay, so I'll take the first question from Fon says, so if everything that identifies a business is a trademark, doesn't this encroach on the sphere covered by industrial designs? I don't know. Chinasa, do you understand that question?
Yes, I do. And I'm sorry if that was what you understood by what I said. I'll be very clear. Everything that identifies a business is not a trademark. And I don't believe I said that really. Everything that identifies a business, it's its brand, right? And so the brand could include the trademark, it could include the logo, it could include the smell, if it's something that has a scent, for instance. It could include the shape, the designs, the name, the colors that are used. So, for instance, for an MTN, the yellow color is part of its brand, right? If you're coming down the street and you see a big yellow box and all that, you could guess, oh, maybe that's an MTN building or something like that. So it is not a trademark. A trademark is a different thing. And I started by saying I didn't want to go into the details of what is IP, the different types of IP and all that, because all of that was covered yesterday. A trademark is basically a name, logo, a mark used on a product or a service to identify it. And I talked about brand and said they are actually two different things, but they are often used interchangeably. A brand is kind of like the totality of everything. So if you say what is MTN's brand, it will include the name MTN, it will include the yellow color, it will include the yellow, that word, it will include their slogans everywhere you go, it will include how they do things, that perception, that image, that's what is the brand. It's not so industrial design is totally different. It's one of the types of IP. You have copyrights, trademarks, industrial designs, know-how, trade secrets, and so on and so forth. They're all different.
Yeah,
Thank you.
We discussed industrial designs and the different kinds of trademarks yesterday. So for everyone, if you want the recording, it's on the YouTube channel. This was recorded and will be posted. Okay, so the next question is, what happens if a trademark is challenged in court by a party claiming original ownership, though the subsequent user had done a diligent search and statutory check, following which it got the trademark registered without notice of previous registration or use by the other brand? So just before you answer, Chinasa, you answered this question. The next question was, where can you access or purchase a trademark journal? The trademark journal is sold by the Trademarks Registry. So just to, and the registry is in Abuja. Chinasa.
Okay, thank you, Nta. And thank you for answering that third question. So it's all a question of fact, right? And it depends. The thing is, the first person in Nigeria operates a first to file. The first person to file a trademark owns the trademark. Well, the first person to file and register a trademark owns it. right? And I don't want to get too technical because under the Trademark Act, it says if you file a trademark, even if it doesn't get registered, if you file it today, even if it doesn't get registered until 10 years' time, whenever it gets registered, the registration date is taken as the date you file. That's what the Act provides, right? So let's just keep that one aside, first of all. But the point is, the first person to file the trademark owns the trademark, except you're able to prove maybe bad faith, or you're able to prove something else, it shouldn't have been accepted and all of that. The law provides the grounds on which you can, challenge the registration of a valid trademark. That is a trademark that has a certificate that it's on the list or in the register of trademarks. So if I don't know what you mean by if you've done your due diligence, because you are supposed to have seen that there was already an existing trademark if you conducted a search. Supposed to. I understand that there are some challenges with records keeping at the registry where sometimes there have been cases where, you wouldn't know or see that, a trademark exists because when you conducted a search, nothing came up and all of that. And then you now proceed. And then for some reason, you get a certificate of registration. Again, that's also worrisome because there's several levels or several stages. Because I said again, at the point of advertisement, if the initial person that registered first had a very vigilant system for its lawyers or themselves or however they handle their watch service to check. They're supposed to check trademark journals that are published every time to see these applications are about to proceed to registration. Is there any objection? And then they should have objected at that point, and the opposition process would have dealt with this before you get the certificate. I would say that it's very rare. I'm not saying that it's impossible because I have seen cases like that. It's very rare that you see that somebody else would go and get a certificate when there's already an existing trademark certificate, in circulation or wherever at the trademark registry, right? But in that case, it now depends. So the court is now going to look at it, I guess, and see, okay, is there bad faith, as in the case of the that case that we mentioned earlier? Is there any bad faith? Is there anything that should make this certificate be withdrawn or cancelled or whatever? And in some cases, there have also been cases where they've said, you know what, there's going to be honest concurrent use. Okay, so you came up with this thing independent of this other person, and you guys have used it, you've even registered it and all of that. I mean, it depends. So I hope that answers your question.
Okay, so Chinasa, the next question is where the renewal is not done as and where due, what is the effect? But before you answer that question, we're thinking about that, and there was a question of, please, does the step towards registering a trademark is applicable? I want to believe it's applicable to copyrights. Please, for that question, if you were here yesterday where Christian took us through, how a trademark is registered and how copyright works. So please just check the YouTube. The session is there, and it will take you through that process because all of that was talked about yesterday. So Chinasa, about renewal, please go ahead.
Yes, and then so just to add to that, I'm aware that Ngozi Aderibibe is going to be talking about copyright in 2 days time.
On
Monday. Okay, sorry. Yeah. Copyright. So that's also an interesting one that you can join if you want to get some more clarity on copyright issues. So regarding renewal, right, under the law, like I said, you're supposed to, under our Trademark Act T13, you're supposed to renew your trademark from after you file, at the first instance, 7 years after you file, and then subsequently every 14 years. And trademarks are very interesting because unlike copyright designs and the rest of them, which have expiry dates, so to speak, with trademarks you can renew indefinitely as long as you just keep renewing. You own the trademark. There are some, I've come across some old, very, very old registration for Coca-Cola and a couple of other well-known trademarks that have been there for years, decades, and they've been renewed up till the present day, right? However, the act says that a mark can be removed for non-renewal. So if you don't renew your mark, the trademark registrar can strike it off the register of trademark. But there's a precondition there. Prior to striking it off the register, the law provides that the registrar is supposed to inform the um, the owner of the trademark or the proprietor of the trademark that the mark is due for renewal, and failure to do that and all of that would lead to within the period given would lead to striking off. So it's not automatic that if you've not renewed your mark, automatically it would lapse. There's that risk that it could lapse, and all that. And in fact, it's even like in terms of a practice thing, because some people register trademarks or apply to register trademark, and then they're not really interested in them, they're not using them, and they're just there acting as a bar to subsequent trademarks that have been registered and used by people in commerce and all of that. So sometimes you have to go and find and maybe start an action to petition the registrar. What can this mark be removed for, because it hasn't been renewed and all of that. But my point is, it's supposed to lapse, but it's not automatic. The registrar has a role to play in that.
Chinasa, this is just as an aside, which, of course, benefits us, as practitioners, and for practitioners who are also on the call. A couple of years ago, the CAC went through its books and advertised companies that were dormant and all of that. So please, can you imagine if, the trademark registrar does that to trademarks, freeing up the register, for other marks that, other people that are looking to register these names, at least in my practice, and I practice at the same time as you has practiced, I don't think that the registrar has ever done that, a situation where, he advertises, sends out, and so that people who have, who have marks that haven't been renewed, marks that they are not interested in, the same way CAC, sensitize the register. It would really, really be great if that can be done for the trademark register. Chinasa, what do you think about that?
Oh yeah, I totally agree with you on that.
Okay. So for the person asking for Chinasa's email, Chinasa, is it okay if people reach out to you on LinkedIn?
Yes, that's fine for sure.
Okay, and for the one for one who is asking for the cases, if you can listen to this recording again, it would Chinasa took her time to read out those cases, and yes, Chinasa took her time to read out those cases. So if you can listen, and we will make of course the slides will be available. The Training Academy, is free to send it to participants. So the next question is, are descriptive or generic trademarks registrable? And if not, why? Before Chinasa answers this question, I would also say, please listen to yesterday's recording. But Chinasa, you're free to respond about generic and descriptive trademarks.
So the answer is no. that's the answer. Generic or descriptive trademarks are ordinarily not registrable. However, we know that with law we always have exceptions. So the exception is where the generic or descriptive mark has what we call acquired distinctiveness or acquired a secondary meaning, right? So I will use a very good example, something like Holiday Inn for hotels, or yeah, Holiday Inn for hotels. That's a very descriptive mark. It's an inn where you go during the holidays or where you go to go and sleep, or and something like that. But because over time they've used it, it's become associated with that hotel line and all of that, it is now registrable and protectable. Now, excuse me, the essence of trademark is to identify a product, it's to identify the source of a product, right? That company A makes this product and not company B. If I walk into Slot, the phone company, for instance, and there are all sorts of telephones on display and all of that. I want to buy a phone. What would make me walk towards the iPhone and not towards the iPhone table or desk and not towards the Nokia desk? What would make me walk towards, it's a lot of things. It's the name. the name, that's a trademark, because it helps me to know. It's the way it is designed, the get up and all of that. If everybody was going to call their telephone, then how would you know where it comes from? Who would you know who owns it? That's a descriptive mark. Do you understand? So it has to have something that is distinct, that would separate it from others, so that people can identify, oh, if I see an apple with a tiny chopped off bit of it, I know it belongs to the Apple company. It's an iPhone product or something.
Okay, so I understand that the link to the YouTube where you can watch the recordings of yesterday to give you, that's going to answer most of these questions has been posted in the chat box. So please click on the link and it will take you to and then you have an opportunity to subscribe so that anytime any recording is put up, you would be notified. Okay, so there's another question on how basically I think the question here is why it takes so long, right? So it says, why is there a delay in releasing trademark certificates? Presently, certificates have been issued now for those that applied in 2023. My question is the paper that was issued for usage. Honestly, Chinasa, this would be a regulator problem. But is it something, okay, so based on your Conga case analysis, when you said that their certificate wasn't out, knowing that it was the fault of the ministry, as a result, they lost the matter at the tribunal. What is the legal effect of the letter released upon registration, since the certificate takes about 2 years to come? Chinasa.
I mean, so your answer is already it's a regulator question, to be honest. We are all in the same boat, let me put it that way, you know. And to be honest, I would even say that the registry has improved a lot from what it used to be. I've had a situation where we're looking for trademark registration certificates, 11 years, some of them more, 9, 10 years, and we didn't have them. And imagine that the client had like a dispute that he had to, resolve involving the trademark. It's something that I think as practitioners we need to work together, to see how to improve the processes at the registry and see how we can assist and work with them to ensure that documents come out as at when due. It's not something that I can say or put a date to or something.
So which for me, what I'm going to add, and of course this is giving out tricks of the trade for those who practice who do IP. I don't know. So for you if you don't do IP every day, you're going to file your trademark and walk away. You don't know anything about what goes on with examination. You don't know anything that goes on with publication. You don't know anything that goes on with afterwards. So it takes a practitioner who does these things every day to understand that, because of the issues of the registry, that you're not just going to, after your mark is published, some people just don't even bother. They just walk away, until when there's a problem. But if that's all if you're in the business of IP and intellectual property law, you would know that once the publication, the 2 months is done, you quickly apply and then you get on that queue. So I would say, of course, the regulatory it is really slow, but like Chinasa said, things have improved. But we will, as a practitioner, you have to work with the registry to ensure that things keep moving forward. So another
Sorry,
question.
I'll just add to that, and I totally agree with you, because that's what I was talking about when I talked about being vigilant. As lawyers, we have to be we can't but be vigilant with our clients' matters. Like, you should even have like timelines, like, because again, I would assume that if a client is approaching, they're going to ask you, how long is this going to take? How long do I have before my return? How long does it take to be accepted? How long does it take to be published and everything? And so to look good, you have to give your clients timelines and also ensure that those timelines are at least met as far as you can, or at least something close to the timelines that you give them, if not. So we have to be vigilant. You don't just file and say, oh, okay, I filed it and all that. It's a tough, how would I put it? It's a difficult one. However, you have to be on top of your game. You have to be going there, reminding them, following up. Sometimes it is that they are bogged down with so much. Sometimes it could be that someone inadvertently did not do what he or she was supposed to do. But you would never know if you just sit in your office and wait for them to contact you and say, oh, this has issued. So you have to follow up. That's just what I would say.
Yeah, and just to add, and this is just to give those who are interested in IP an inclination as to how our practice works. There is no serious trademark or IP practitioner that doesn't have a good record keeping system. Because if you don't have good record keeping systems, how are you going to know what is coming up? All of us, for those who are in serious IP and trademark business, you have a system in place. You have technology that reminds you of these things. They pop up, once you get to work, that this thing is due, that is due. A fantastic record keeping systems. Of course, things, slip through the cracks, but, on the face of it, you have to have good record keeping process, because once you have good record keeping, you know that, okay, once you file a trademark, it would say maybe examination is within 4 to 6 weeks. That after that within that period, after that period, you need to go and follow up and check. For me, that is the only way. You have to keep good records, and you have to have systems in place to remind you to keep checking on these things. That's how to get things, out of the registry. So Chinasa, there's a question, is during the webinar, you referred to a clearance search before adopting any brand. Please expatiate. This is simple, but go on, Chinasa, please. Chinasa, are you there?
I was muted. I didn't know. Sorry.
Please go on.
Yes. So it's simply just we call it an availability search, status search. Well, an availability search in this case. So you apply to the registrar, you pay the requisite fees, and apply to the registry to check if, so using the example I gave, Chinasa, I want to register the trademark Chinasa. I would apply to the registry to check if the name Chinasa is available in class whatever. So is the name Chinasa available in class 45, for instance, right? The registry will conduct its own internal searches, and as long as you paid the fees and all of that, and would give you the results. So that answered the question. That's how you do your clearance check, to check that. Okay, so and then typically what would happen is if there is any similar trademark, they would also let you know. So if there is, my name is Chinasa, if there is Chinaza, Chinaka, Chinala, China, things like that that might be, confusingly similar in that class, the registry will flag it and let you know. I think that's it.
Yeah, that's it. So this is not, I don't know if someone is asking, someone wants to register waste management services under what class? I don't think that this this session is meant to address that.
No,
But
it's fine. It's class 40.
exactly, if you go online and you just go get, just check trademark classes, like yesterday's training and today's training has told you NIST classification. If you check, it is there. It is, public documents where you can check all of these things. There is a question.
Yeah, sorry, just to mention that NIST classification, you can find it in WIPO's website. WIPO is just WIPO.int. Check for the NIST classification of goods and services. You will find the most recent edition of the NIST classification, and you can check. But again, just for whatever it's worth, class 40 deals with waste management, treatment of materials and all of that. So that will be the appropriate class for that.
Okay, this is an interesting question. They say where there's a conflict between a registered trademark and an unregistered trademark under common law protection, which takes preeminence over the other? Quite interesting.
I mean, so like we said during the conversation, the registered trademark, right, takes preeminence ordinarily, except in the case that you're able to show otherwise. So if you're able to show that you had prior common law rights under the law, you're not passing off, it's not, or whatever, the court might rule for honest concurrent, existence or use of the mark and all. But if you're not, and that's the thing about unregistered rights, it's the burden of proof is on you. Do you get? If I've registered my trademark at the registry, all I need to do is, hello, this is my certificate of registration. The burden shifts to you. You need to go and prove that, oh no, you also have a right to use, or maybe I don't even have a right to use, or that you have a right as well to use. Do you understand? So it's the first stage is the first person that filed to get the certificate. That's why we advise people to rush. Don't wait. Don't think about it. Even if you've used it, even if all people associated with you, even if they know you already that it's your brand or whatever, go and register it. It gives you that first point that's all you need to show the certificate that you have it. But then the other party on the common law now needs to prove, no, this is my great 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 grandfather's and we've been using it. We bought it. We have good people know us by it. And it's not just by word of mouth. It's a question of fact. You have to prove your evidence. You have to bring it out and all of that. Yeah.
Okay, so an interesting question here says, can one place a charge on a trademark or any other IP in a similar to placing a charge over a legal mortgage? If yes, how is it done?
Yeah, answer.
Okay, so IP rights, like trademark is, of course, is an intangible right. So if you wanted to do this, the most common way that I know that it is done in Nigeria is as a license or an assignment. But whatever you do, if you decide to do this, give your trademark as a mortgage, it is not going to be effective until it is registered at the registry, right?
Yeah.
So whatever arrangement that you make with, whoever it is, you need to register it. And the two main ways that I know that it is registered at the registry is either as a license or as an assignment. Chinesa, I want to believe I've covered.
That's fine.
Yes. Okay, so then there's a question on okay, so this person is asking, can you register in all the classes of business, even when such a product is not relevant to the particular class? This was answered yesterday, but Chinasa, please, I'd like to hear how you
Okay,
what.
so so that's something that is called defensive registration, right? Defensive registration is where you register in all the classes. So the starting point is that trademarks are registered in accordance with classes. You cannot just register a trademark. There has to be a class, or whether class 1, 2, 3, 4, 5 up to 45 and all that. But then you have to register it in relation to goods or services that you deal in, right? So if, for instance, as not even as, for instance, I am a lawyer, right, and I'm not into cosmetics, production of cosmetics or whatever, I have no business going to go and file my company name or my whatever I'm doing with in the name of under class 3, for instance, right? Because class 3 would have a specification of goods, a description of the goods that fall under class 3. So you have to register whatever you're doing. Or if you make food, let's say you sell drinks, beer or whatever, which would fall under class 33, you have no business going to go and register it in class 16 that deals with paper and paper articles and all that. However, like I said, there's something called defensive registration, which means that because it means just simply registering in all the classes, but you can't do that unless you're well known or you're our law is famous. I think our law says famous, or is it well known that that's the language of the act. In some jurisdictions they say it has to be well known, some say it has to be famous. It has to be a famous mark or well-known mark. And I'll give you an example. The easiest one is Coca-Cola, right? And I'm aware that Coca-Cola has registrations in the 45 classes because they are so well known. So let's say you make shoes. Class 25 deals with shoes, clothing, articles, and everything. Under normal circumstances, Coca-Cola has no business. It's a drinks company. It has no business going to go and register Coca-Cola for class 25 that deals, but because it's going to look crazy to see somebody walking on the street and say, "Oh, I'm into, I'm the newest Vicky James, and my outfit is called Coca-Cola." Everybody's going to say, "What Coca-Cola they drink?" It's so well known, it's so popular, it's so famous. MTN has defensive registration in all the classes. You can imagine saying, "Oh, we now have MTN paracetamol or something like that." So because it's so well known, it's so famous, they can really decide that is the only exception the law grants you to register defensively. FIFA, very well-known companies like that, but every other person, you have to register for the product or services that you use the mark for.
Okay, so there's this question that I think is actually directed at me because I'm the one that made that comment, and the person says that because I said that the practice of IP, it's in the doing. So if a lawyer has no clients in this IP, how would they be doing so as to keep practicing? I'm going to close the chat box so that I can answer this question. And before I answer this question, I'm going to read out Chinasa's bio. Then when I finish reading out Chinasa's bio, I will, you know, it would thoroughly kind of like help us understand what I meant by, yeah. So Chinasa, this is not to put you on the spot, but let me read out your bio. Maybe that you will understand what I mean by in the doing. By reading out your bio, it would explain, because as far as I know, you are IP, in person, because this is all you have done. So Chinasa is an experienced legal practitioner with a track record of 17 years in intellectual property law, technology, media, and entertainment space. So she started her practice at the law firm of Jackson Etienne Du. After Jackson and Etienne Du, she went to Alukwano Yebode, and then she went to Banwa Nigudalo. These are three well-known firms, yeah, as well as a Canadian firm, Lawson and Creamer, where she advises numerous local as well as cross-border multinational, multi-jurisdictional transactions involving brand registration, transfer, commercialization, protection, and enforcement, particularly in Nigeria and other African jurisdictions. She also advises business owners on regulatory issues with particular reference to IP rights. In addition, her experience cuts across corporate and commercial law transactions, consistently ranked as an expert in the field of IP in Nigeria by Chambers Global Guide, and more recently by the World Trademark Review 1000, World Intellectual Property Review, and Managing Intellectual Property IP Stars. Chinasa is an author and regularly speaks on IP and ancillary issues. She's an active member of many local international IP organizations, including the Pharmaceutical Trademark Group, International Association of Protection of Intellectual Property, AIPPI, the Anti-Counterfeiting Collaboration Nigeria, Intellectual Property Committee of the Nigerian Bar Association Section on Business Law, that's SBL, amongst others. She has served on several committees of the International Trademark Association, including the Middle East and Asia Anti-Counterfeiting Subgroup. Until recently, she was the Nigerian chapter contributor for the INTA Country Guide on Trademarks, as well as a contributor of the Future Africa Forum on Development and Industrialization Issues. She has a master's degree in IP law from the University of Turin in Italy, WIPO, and from was also in connection with WIPO, a master's in business administration from the University of Brunswick, Canada, where her focus was entrepreneurship, technology management. She's also a registered trademark agent with the College of Patent and Trademark Agents in Canada. And she recently qualified for the Ontario Bar Canada. So I wanted to read this out first before I now, if you, which is what I said, that IP is in the doing. From starting her practice in Jackson Etianedu is known as an IP, they have a very large IP practice. Then she moved on to Alukaniyobode. In fact, Chinasa left Alukaniyobode and I took her place at Alukaniyobode as in the IP department. Then she moved on to Banwan Gudalo to do IP. So when I say that IP is in the doing, Chinasa, I don't know, please correct me if I'm wrong. Chinasa does, she's seen IP in all forms, shapes, and sizes in Nigeria. And even when she has, she lives in Canada and in Nigeria, she still does IP. So when I mean it's in the doing, when I wake up in the morning in my own practice, I manage my own practice as Next Legal as, managing partner. It is a boutique IP law firm. That is all I do. So when I wake up in the morning, when you are in the practice area, you will see the opportunities in that practice area. You will understand how that practice area works. So that's why I say it is in the doing. Chinasa, do you want to add anything to all that I've said before we get on with the rest of the questions?
You didn't want to put me on the spot and proceeded to do so. I don't know what to say.
All right, Chinasa, when you finish, I'll add something. So go ahead.
Okay, so I'll just say that, to practice IP, you have to look for opportunities to practice IP. Basically, you have to look for clients, you have to attend IP events. And the good thing about IP is that there are numerous IP events. There are so many IP conferences going on almost every month of the year round. You go there, you meet clients, you meet business owners. You have to start writing on IP, advising clients on IP. When a client gives you, even if it's a litigation brief, you want to look at the IP issues. If they give you any commercial brief, any agreement, you have to look for I talked about it earlier in my talk. Look for IP clauses. Are they there? Are they not there? Is there any IP implication? What comes? And that way you begin to build your practice. You get people that you can advise on IP. You can tell them what's going on, and what they should do. You would have, I recently was talking with someone on something totally different. And by the time the conversation was over, I was about to register 65 trademarks, right? It's about looking for the opportunities and all that. And those opportunities would come when you look for them. The opportunities will actually come, So that's how you start to build your IP clientele. Thank you.
Tobina, you wanted to say something?
Yeah. So I think there's too much sound coming in where I am. I don't know. But
if you move
I'll
back.
just say back enough. It's something to do with the lighting. Anyway, not a problem. I think that the first point to make as far as the question that was asked goes is that it's probably one of the most important and significant questions that any participant at this training could ask, especially considering the terrain, the legal profession terrain in Nigeria, where you have too many people who don't have an opportunity to get a foot in the ladder within the context of a given area of expertise. And I think that Chinasa captured it very well when she said that you have to look for those opportunities. You have to start looking for things that are related to IP. And I think you've taken the very first right step by attending this event. Second right step of asking this particular question And then you have to look to take all the steps of actually shopping for the work, looking for people, taking an interest, discussing with the clients that you have already, seeing whether they have any trademarks that could be registered or patents or whatever it is, and start a conversation in that area. Make friends with people that practice in that space, so that even if you have to do basic rudimentary work around IP to build some sort of retinue of work or footprint, that you discuss with people like Nta and Chinasa, make friends, build networks, ask them where they go to, ask them what they do, how they do it, and then gradually you start doing it. I think the point Nta makes clearly is that to become adept at whatever you do in legal practice, you must do it. It has a lot of theory in it, but it's based on practice. And that's why we call this academy the Practical Training Academy, because law is about practice and practicals. Thank you. I hope that helps.
Yes, it does help, Tobina. Thank you. And just to add to, what Tobina and Chinasa have said, Chinasa and I, even as having our own practice in where we sit, in different countries, we share ideas all the time as to, okay, so what's going on? Where are we going next? What needs to be the strategy? Because if you want to grow in a certain space, you have to surround yourself with the people of that certain space. If you go to my LinkedIn now, you would see that most of my connections, are mostly people in this space. So if you're looking to build a practice in that space, there is a method to, in quotes, there's a method to the madness. So you have to, it's like, any other space, people, there are people who just do disputes, right? They are dispute lawyers and they have cases every day because they have built. So you start step by step, but it is something that is very doable because so many people are doing it. So I guess we've been able to share more light. You can always reach out to either one of us, on LinkedIn, and we're happy to continue to share. So now I'm going to go to the next question. So the next question is, could you throw more light on registering a person's name as a trademark for consultation services? How possible is that? I think, Chinasa, when you mentioned using your name, it was as an example. I don't know if you meant it, but you're free to answer.
Yeah, so to be honest, I use it
It was
as
an
an
example, yeah. Okay, so another question.
you
It's
know, just
sorry,
quickly just mention that the trademark does talk about registering
your
your
name.
name, and I don't think it's one of the things that are allowed. Again, unless it has acquired a certain level of distinctiveness, right? Something about I think section 9 that talks
Yeah.
about distinctiveness required
Exactly.
for
If not, all of us
registration.
will be registering our names up and down the place. Okay, so the question is trademark superior to company
That
registration?
was funny.
Sorry, sir. Sabrina, what did you say something?
See, that's quite funny. Because the way people just call me to bring that to all the time, sometimes I wonder whether I should register them.
No, please. No, please, because a trademark is meant to and how it's meant to stop other people from using it. So if you go and register to be it means that you're trying to stop other people from no, Chinasa, I want to believe. Did you want
So let me read out what the act says. Capti 13, section 9 says, talking about registration and validity of registration, in order for a trademark, and I'm sure this must have been dealt with yesterday. In order for a trademark other than a certification trademark to be registrable in Part A of the register, it must contain or consist of at least one of the following essential particulars. And the first one says, as in 1A says, the name of a company, individual, or firm represented in a special or particular manner. So you can't just register your name like that. It has to be represented in a special or particular manner. And then there's a proviso. It says, provided that a name, signature, or words other than those such that fall in A to D shall not be registrable, except upon evidence of its distinctiveness. Basically, if your name is not distinctive, there's nothing that has distinct. So some people would either put their name with a logo or add something to it or blah blah blah. I don't know. However you want to, it has to be in a special or particular manner. Otherwise, it will not be considered distinctive and you can't register it. I just wanted to read out that portion from the act.
Okay, so there's I don't know if I read that question about is trademark superior to company registration? Between trademark and business registration, which is advised to be done first? Chinasa.
To be honest, I can't speak to the superiority of either. It's all it should form part of your strategy. It's like saying, oh, should I register my trademark or should I do a leave it as a trade secret? That kind of thing, or register a patent or leave it as a trade secret. It depends on your strategy. It depends on a lot of things, the commercial decision, your finances, well, how much do you have available at the time. If I had funds available, sufficient funds available, or my clients had sufficient funds available at the time, I would advise them to conduct searches at both registries, do both, you know. And again, it depends. Again, so if your company name isn't something that it's necessarily your trademark, then you might not even want to register it. So I'll give an instance of the Coca-Cola company, but they have Fanta, that is a trademark. They have Coke, that is a trademark. They have Sprite. The trademark is Sprite. I mean, in their own case, they also registered Coca-Cola as a trademark, but the name of the company is the Coca. So I think in Nigeria it's something bottling company, or so it's not even Coca-Cola company or something like that. But then they have various trademarks. So again, it depends. It's your strategy. It depends on your client's particular or peculiar circumstance and what they intend to achieve. But then there are also some trademarks that are also the name of the company, the name of that they use for their domain names and all of that. So in that case, you probably be better off registering all of them at the same time.
And just to add to that, for me, I always tell my clients, who do you want to own the trademarks? So if you want it to be owned by your company, or if you want it to be owned by you personally, then that's also something to consider before doing either trademark or company registration. So, a question is, must there be an objection to a proposed trademark registration before registration will be declined, or the registry has powers to suo motu refuse registration? What are the options available to a person whose trademark is refused or objected to?
As a three-in-one question.
Yes, and a part of it was answered yesterday, but Chinasa, go ahead.
So in the trademark registration process, and I didn't really go so much into that today, there we have what you call official examination, right? And just as you have official examination, you have official objection, you know. There's also third party. So you could have official action and third party action. That's the way I try to explain it. Official action is usually what comes from the registry directly. So when you file a trademark, it goes through the official examination process. At that point, the registry could raise some objections. They could say, like I mentioned when I was talking, like they could say, oh, there's already a prior mark on the register, a confusing prior mark on the register or an identical prior mark on the register, as the case may be. Or they could say this mark is disallowed by the law because it's against the law, it's scandalous, it's there are other reasons why it's immoral and so on and so forth. There are other reasons why the registrar could raise an objection. So that's called an official action, you know. Or you could say it's descriptive. They could even just say it's descriptive. It describes you want to register tomato for tomato paste, right? That's a very descriptive trademark. The registry can raise an objection in that case. So that's an official objection. On the other hand, we also have what we have third-party objections. An example would be the opposition that I mentioned earlier. during the process of registration, after a mark has been accepted for registration, it is published in the Trademarks Journal for any interested party to, comment or make or oppose or whatever. So if anyone objects to it, at that point in time, it's being objected to by a third party. It's not necessarily the registry. The registry has accepted it and published it in the Trademarks Journal, and a third party is now objecting to its registration. So there's that. Again, a third party could even file cancellation proceedings, at the, let's say for some reason it goes through and you get a certificate of registration, but they allege infringing mark, you could go to the Federal High Court and file an action, cancellation action or invalidation action, as the case may be. So it mustn't be third party, it mustn't be the registry, it could come from either side, but then it depends on the stage of the registration process.
Okay, yeah. So I think just to add, like you said, is official action and third party action. So one happens at the point, all of it happens at the point of registration. The first one is when it is being examined, and the second one is when it's being published to the whole world to say, look, do you have any reason why this trademark should not be registered, and it is opposed. If your mark goes through all of those processes without an objection, you have a trademark. Okay, so someone asks, please kindly share some of the technological tools that can be helpful with record keeping as advised. I want to believe that I was the one that talked about technology. So, both Chinasa and I have worked in, the biggest law firms in one of the biggest law firms in biggest trademark law firms in Nigeria, trademark practices. And technological tools, they come in different prices and different things that you're looking for. So I would say that if you're starting your practice, you're actually going to, you might not have the money to actually go big. You're looking for something very simple. And something very simple could be something like, your Google Sheets, your Excel document to be able to help you to keep records. Anything that you're just going to keep records and, it quickly arranges it for you. You can actually start with that. For us, in our, in the different practices that we've had and, that we use, there are different technology right now that, there's some technology that actually starts from when you receive an email, an email instruction. It automatically just, registers it so that, the only other thing you're going to be doing is maintenance. So some of these things really cost money, but for this rudimentary level, if you're just starting out, you could just start with things like, your Microsoft Office, record keeping tools. Chinasa, is there anything else you would like to add to that?
Not so much. I think you've answered it pretty much. There are a lot of IP software that could be used, like you said, Patricia, Anaqua, Fileye, and so on. But then there are also your simple Microsoft Word, or your Excel sheet and all of that. You could use them to, set reminders, draw up tables and all that, and follow through, regularly check to ensure that you don't miss out on any due dates and so on. Yeah.
Okay, so there's a question. The question is that can registration of traditional, I don't know whether it is traditional or trade. Okay, I want to think it's trademark with a slight difference with the existing one allow. So I want to believe he's asking whether you can make a slight difference to an existing trademark. Will it be allowed, such as registering like all music association while there's an existing music association? Chinasa, do you understand that question?
What I would answer what I think I understand.
Yeah.
It is that if you already have, let's say there's a word, can the addition of more words or something like that, change or make it more registrable or distinctive? Well, I would say it depends, right? It depends. And the reason I say that is that it is actually one of the strategies we use when we have a client that comes with a very descriptive trademark, and it looks like, oh, can this trademark fly? Would it not be? You could typically, what would happen if it's very distinctive? The registry can even ask you to disclaim the very common or generic words. So if everything in your trademark is are generic or common, then you don't have a trademark. Even if they say, okay, you can proceed to registration, because it doesn't stop anybody else from using it. So we would typically say, you know what, add something that would make it distinctive. Now, so if you let's say you have a trademark that says using the example I gave, tomato paste, right? And they first it's, let's say, toma is even descriptive in my opinion. Gino tomato paste, for instance. Tomato paste there might form part of what was filed as a trademark, but we all know that tomato paste is not distinctive, because it actually describes the product that for which the trademark was filed. So in this case, what would be the distinctive thing there is Gino. Even though if they are filing it, they might put the three words Gino tomato paste. The actual trademark there would be the Gino and not the tomato paste bit. So if I want to file another trademark and I say, but Gino, I did a search and what came up was Gino tomato paste, can I go and put something else to now make it distinctive? It's not going to be distinctive if you make it Gino Chinasa tomato paste, because Gino is there and Gino is a distinctive, trademark. It may be different if you say Chinasa tomato paste. So because tomato paste doesn't really belong to anybody, no one can really claim it might fly. It would likely fly because the distinctive thing is there. So what I would typically advise clients, amongst other things, is it's not just adding, additional words to an already distinctive trademark that would make your own different and, make the registry accept it for registration. You might look to adding something like a logo, if your trademark is Chinasa tomato paste and you feel they might object to because of the tomato paste, add a logo, add a stylized version of it. Look for ingenious ways to add a drawing, a picture, something to your logo or to your trademark to make that trademark. You know, I mean, there are a lot of, I wouldn't want to call them tricks, but there are little things you could do, to help your trademark to enhance its registrability.
And yeah, using the example that you've said, music association. So music association is not distinctive. If you wanted to, go and register musical association, it's not distinctive. That's not a trademark. So, but if you go to say, take for instance, something music association, the other music, yeah, in those instances, you can actually do that. Yeah, we just have 8 more minutes, and I think there's just one or two questions left. So let me see. What happens if a trademark is challenged by court by someone claiming original ownership? Do the subsequent Okay, no, I think we've answered that question. We've answered that question before, and I'm just trying to see that if there's another question that we haven't, if there's any question that we haven't answered. Okay, I have said that all the cases that Chinasa mentioned, she read them out. So if you go to the link for the YouTube channel has been posted. So if you go there, you would see, you'll be able to listen and get, all of those cases, and all the training, the practical training academy trainings is on that YouTube channel. So I understand that we've done labor and employment law. There has been a training, so it is also there. And now and this is now IP. it is being uploaded. Yesterday's own was uploaded and today's own is going to be uploaded, so you can actually go and listen to it again. Tomorrow we have a training on enforcement, and then on Monday we have another training, I think on copyright. So on I think we've answered all the questions, all of it, all the questions that were sent in for us to answer. And Chinasa, do you have any closing remarks before I hand over to Tobina? We have about, you say, 6 minutes. So yeah.
Yeah, just to say a very huge thank you for the opportunity to have this conversation. Like I said, I'm very passionate about IP, and I'm always happy and willing to talk about it. And even for the stimulating questions that were asked, it helped to also buttress some of the points that we had earlier discussed and shared. And then just to encourage anyone who is interested in practicing IP, it's very doable. It's something that is very rewarding, and it's something it's an area of practice that you should think about, you should seriously consider, but not just consider it. Even if you don't want to go fully into intellectual property, whatever type of practice you have, make sure that you're protecting your client's IP rights. You're looking out for relevant clauses, relevant ways to help them have tight agreements and avoid conflicts. Be proactive, don't be reactive. If you wish to reach out to me for further questions or mentoring or something like that, I'm very happy and always available to do so. You can reach me through my LinkedIn. My name is just China Salwana on LinkedIn, so you can always reach out to me or reach out to Nta Ikeng Ang as well on LinkedIn. Nta has a very thriving practice, and I know she's willing to help as well, so you can always reach out to her. And yeah, and then follow the academy, because we have, apart from the IP, we have other trainings. I know we've done one on employment law. Not sure which one is coming after the IP, but I bet Sabina would
Yeah.
talk about those ones. And these are, I think, just use this opportunity. They are free lectures. You're getting your CPD points up, and not just that, but you're learning from people who have experience in the field as well. And it's going to be very useful for life. Thank you very much.
Okay, then. So for me, I'm here.
Whoa.
Sorry, Tobina, I was about to give my own closing remarks.
Go ahead. Please do, please.
Okay, so I'm here tomorrow to also moderate Mr. Gaba's session. It's going to be interesting. Mr. Gaba is, he is a guru on enforcement of intellectual property rights. So it will be good for you to actually listen, come and take part, listen to that training. So what we have done is we're taking you from the beginning, which was yesterday, the foundations of how intellectual property works, how you protect and all of that. Today, Chinasa has come to talk about the practical parts of, the nitty-gritties of it. Then tomorrow, Mr. Gaba is going to be talking about enforcement. And, he's going to be telling us how to actually enforce your rights, infringement, different things. So it will be a good training to take part, to participate in. For me, I would say IP. IP is interesting. IP has taken Chinasa and I to, different corners of the world. There's always an IP event going on somewhere, so you're actually picking and choosing. Right now there's Hollywood, INTA is in Hollywood. Do you want to go? There are so many interesting and different things. Yeah, we why most of these trainings and these events are happened outside the shores of Nigeria is because we have come to understand that sometimes Nigeria is playing catch up. Most of our Nigerian companies still don't understand how IP works. A survey was carried out a couple of years ago to see that most of the trademarks that were registered at the Registry of Nigeria were before, so post 2012, were mostly done by foreign companies. But between 2012 and 2020, we found that Nigerians were registering their trademarks. They had overtaken the foreigners in terms of trademark registration, which is to show that, Nigerians are actually waking up to, the consciousness of why you should own a trademark. You would know that you can't own, you can't have a drug, an FMCG, products without registering a trademark with it. You can't go to NAFDAC without a trademark. So Nigerians have started waking up, manufacturers have started waking up to the fact that you should protect your intellectual property rights. And I must say that, we found that people who registered the most were either in the north, and they were also in the east. So Tobina and Chinasa's brothers and sisters, were registering their trademarks a lot, so it is interesting. It is really interesting to see. So yeah, Tobina, and of course I'll be back here tomorrow, and I'm happy to answer any questions if you reach out to me on LinkedIn, and also tomorrow. Tobina, thank you again, and over to you.
Yeah, so before I make my closing remarks, I just want to say to everybody that this is a giving back session. It's all about giving back. And I'll ask the people who are still logged on to do us a favor. The link to our YouTube page is showing on the chat box at the moment. And it would be nice if as many people as on this call subscribe, because we have all the videos from our sessions on our YouTube page, our YouTube channel. Now, the big thing, we've got all the tradings on employment law there. We've got the ones for IP recorded and stored there. It's all there for you to access for free. And I'll also ask that you follow us on all other social media pages, because you easily find out what we're doing. First of all, I am very grateful to Chinasa and Nta, particularly grateful to them for all the support that they have given to the Practical Training Academy, and indeed to me over the years, especially when I was chairman of the Board of the Institute of Continuing Legal Education. The very first training that we did at the MBA ICLE on Zoom was on IP law, and Chinasa and Nta were there organizing, putting it together, attracting other experts, Professor Shodibo, Femi Agaba, and others, Uju Tudor, and others. And they've been there like a solid rocks around. Even when we set up our mentorship initiative that we're still working on, Chinasa was driving and pushing everything and putting things together. And Nta was also there. And I just want to acknowledge these two great women who are very willing, as you can see, to give back. And I think that it's important that we also learn from this attitude of giving back. By the way, Chinasa is right there in Canada, and I can't even think of how inconvenient it would be to be doing this. I know how the Western world is. And she's doing it, and she's done it at no cost to the Practical Training Academy or to you or me. And the same with Nta, who's been here since yesterday and promises to be here tomorrow and next. So it's a huge thank you. Chinasa, well, I mean, I always like to listen to you and your presentations. I loved the session itself. It was very quick, but very detailed and very clear. And then I loved the question and answer session much more, because you brought out the best in you as you could, just explaining to people. And I like the fact that you also took time yourself and Nta to tell people how to get on the ladder in very practical ways. And that's what we're thinking about. Hopefully, at some point, we will be able to assess the impact that the work that we're doing is making. And I hope that we continue to spread the word. Thank you very much, and God bless you all for what you do. Thank you.
Thank you, Tobina. Thank you.
Thank you. Bye-bye, everybody. Chinasa, I hope it's not too cold now.
No, it's not.
All right. Okay. Take care. Bye-bye.